I could have got NGRI.
NGR or NGRI pleas, not guilty by reason of insanity pleas. Like the public doesn't understand sometimes, the public will believe that if somebody gets a not guilty by reason of insanity, that means that, oh, they got off. You're charged with assault of a pregnant person as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That's correct, Judge. And if I just may speak briefly on
Yes.
that topic, I've been able to communicate reasonably and clearly with my client ever since he's been deemed restored. He was at the Kerrville State Hospital for competence restoration services. In my opinion, that treatment did take. He was deemed competent and referred back to this court. In discussing the case strategy and the possible disposition of this matter, my client has notified me he wishes to waive the defense of insanity and proceed with the plea at this time, as he is competent at this time, and he does wish to make that waiver, and which is knowingly and voluntarily made.
All right. Mr. Jimenez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
And
No, well, here's the thing. I understand that sometimes people want certain things, but I always tell people a defense attorney can't force the state to give somebody what they want, right?
I could have got NGRI since my offense was. I can't be in the hospital for 20 years because the offense is 2 to 10.
Now, let me explain something to you, Mr. Jimenez, about the law, because I've done a lot, right? So I've represented clients as defense attorneys, as a defense attorney, when they had mental health issues, right? Now, let me explain to you about NGR or NGRI pleas, not guilty by reason of insanity pleas. Like the public doesn't understand sometimes, the public will believe that if somebody gets a not guilty by reason of insanity, that means that, oh, they got off. Sometimes a not guilty by reason of insanity for a person's client, it's worse for the client in the sense that the length of time that you are supervised is whatever the range of punishment is. Now, on another part, it's sort of good for your client because your client is supervised, your client has case managers. So your attorney, and I'm sorry, I overheard a little bit. Your attorney is correct. So you have 3 counts in your indictment. Count 1 is aggravated assault with a deadly weapon. Normally, if you're just on your standard probation, the length of time you're allowed to be on probation for this specific law offense is 10 years. But with a not guilty by reason of insanity, that aggravated assault, you're supervised for 20 years, whatever the range of punishment is. So for example, if you're charged with murder and you do a not guilty plea by reason of insanity, your range of punishment to be supervised under that NGRI plea is life. So for you, count 1, you're looking at 20 years of supervision if you were found not guilty by reason of insanity. Count 2, you're looking at 20 years of supervision if it's not guilty by reason of insanity. Count 3, which is a third-degree felony, you're looking at 10 years. Now, if you want to do a not guilty by reason of insanity plea, I don't know, you all will have to negotiate, but then the state may be saying, no, we're not just going on count 3. We're going on count 1, we're going on count 2, and we're going on count 3. So that's where we are. You understand?
Yes,
So are you satisfied with the way you've been represented?
yes, Your Honor.
All right. If you're not a US citizen by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, Your Honor.
All right. The court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
All right. According to the plea, the state is waiving counts 1 and 2. They're only going on counts 3. They're asking that your punishment be assessed at 10 years in the prison. Did you understand that to be your plea?
Yes, Your Honor.
Defense and state, is that the plea?
That is the plea, Judge.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Judge.
Then to count 3, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Judge, we offer to say exhibit number 1, including all attachments.
Without objection.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Off the record for a moment. Is the door unlocked?
It's unlocked, Judge.
Okay, thank you.
Yes.
All right, we're back on the record. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor, if we may.
Anything you wish to say on behalf of your client?
Well, Judge, Mr. Jimenez has been in custody ever since this charge. He's been battling competency issues. He was in custody about 300 days before he got transferred to the Kerrville State Hospital, at which time he was restored to competency.
They can come in.
He successfully completed those days at that Kerrville State Hospital from February 11th, 2025 to July 17th, 2025. We'd be asking the court to grant credit for his treatment that he was getting for competency restoration. My clients did learn a lot, and he has come a long way once I first got the case to how he is now, understanding the court proceedings. He did tell me that he does suffer from degenerative disc disease, and he wanted me to let the judge know about that, to see if there's any way that TDCJ could be made aware of that in advance. I told him I had never made that request of the court, but that the judge here, Ms. Stephanie Boyd, would be able to opine as to that, and he seemed comfortable with that, Judge. But he wanted me to tell you about that issue that he has with his physical health. His mental health has come a long way, which I think reading the offense report, the court is able to grasp a better sense of the things that he was dealing with. But we're asking the court to respectfully accept the plea offer recommendation from the parties, and to give him credit for all the time he's entitled to.
So after reading the police reports and everything, I understand that there were more issues that were going on with you, that this wasn't something you just did because it was, oh, let me just hurt somebody. So I understand. But you're going to have to make sure that you stay on your medications and not mix anything else with medications. A lot of times people will self-medicate, right? You can't do that because then you end up here, right? So I'm going to find you guilty. I'm following the agreement. I'm going to sentence you to 10 years in the prison, give you credit for any time served. I know that you were residing with your parents. Are there any minors in the home?
No,
Okay.
my parents are 88 years old or
Yeah,
maybe.
but I mean, sometimes, grandparents end up taking care of grandchildren. That's why I'm asking. So there's going to be no residing in households with minors, no unsupervised contact with minors. And then there is going to be, I think I said, I'm going to give you credit for any time served. I'm going to ask for the therapeutic community, the mental health unit. And also I'm going to have them put in there that you suffer from physical health issues. Now, while you're at the jail, your medical record should follow you to the prison. And they will also, at the prison, they will do a physical and everything for you. If that doesn't happen, just let us know. I'm sure, let your attorney know, let me know. But your medical records usually follow you to the prison. Okay? And then when you're processed at the prison, they will do a process where they will process you in, and they will get all of your medical history, all of your mental health history, and it'll be on the judgment as well. So they'll know that I've said that there's some issues, okay?
I'll have a history of my medical issues in the Kerrville Hospital too.
Yes. And you'll receive credit for the time that you were in inpatient treatment at the hospital as well. So legally, you're supposed to have that. And Mr. Munoz, if you'll make sure that the time credit is correct.
Yes, Your Honor, will do.
All right. Did you review the trial court certification of defendant's rights to appeal with your attorney? It's the document telling you whether or not you have the right to appeal.
Yes,
Did you understand it and sign it?
yes,
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over that, you need to speak to an attorney, okay?
yes.
And when you're released from custody, we're off the record, when you're released from custody, I know you're probably gonna want to go back and stay with your parents.
Hmm.
So it'd probably be best for you if you talk to them or talk to your brother beforehand and find out if the persons who were complainants in this case are still there, because you don't want to have any problems, okay?
No, I don't wanna live over there
Okay,
at all. We live in another place.
all right. Well, make sure you stay on your medications, and if for some reason there's some side effects, you got to let the doctors know you're experiencing side effects, okay? All right, good luck to you, sir.
Thank you. Have a good day.
Oh, you too. Bye-bye.
You judge.
All right, thank you.
Under Texas Penal Code Section 22.01 and Section 22.02, the defendant, Gustavo Jimenez, was charged with assault of a pregnant person, classified as a third-degree felony. The statutory punishment range for this offense is 2 to 10 years imprisonment and an optional fine not exceeding $10,000. The state proceeded on count 3 of the indictment, formally abandoning the remaining counts. The defendant entered a plea of no contest pursuant to a negotiated plea agreement. The court, after reviewing stipulated evidence, including police reports and written statements, found sufficient evidence to support a finding of guilt beyond a reasonable doubt. The court accepted the plea agreement and imposed a sentence of 10 years confinement in the Texas Department of Criminal Justice. The defendant was granted credit for time served, including custodial detention and inpatient competency restoration treatment. Pursuant to Texas Code of Criminal Procedure Article 46C, issues relating to insanity were waived by the defendant, who elected to proceed with the plea despite prior mental health considerations. As this was a plea bargain case, appellate rights were limited under Texas Rule of Appellate Procedure 25.2, and the defendant waived the right to appeal, except for matters raised by written pretrial motions. The conviction results in a permanent felony record and statutory prohibition on possession of firearms under Texas Penal Code Section 46.04.